We are now going to discuss American Convention on Human Rights. The Bogota Conference of 1948 have expressed a tentative interest in proposal that an inter-American code be created to guarantee the basic rights of man. But no further development occurred until the fifth meeting of consultation of Ministers of Foreign Affairs at Santiago, Chile in 1959. The meeting resolved that the Inter-American Council of Jurists should prepare a draft Inter-American Code for the protection of human rights. The same meeting decided that an Inter-American Commission on Human Rights should be organized. The Commission came into being in 1960 as an autonomous entity of the Organization of American States, the function of which is to promote and respect for human rights. Its 7 members are elected by OAS General Assembly and act independently without representing any particular country. For the text of the statute as approved by OAS General Assembly in Resolution number 447 in October 1979, the culmination of blatant American interest in human rights was Inter-American Specialized Conference on Human Rights, San Jose, Costa Rica, from 7th of November to 22nd of November 1969. American Convention on Human Rights was signed on 22nd November 1969 by the following states: Chile, Colombia, Costa Rica, El Salvador, Ecuador, Guatemala, Honduras, Nicaragua, Panama, Paraguay, Uruguay, and Venezuela. The convention provides for a commission and a court and bears a general resemblance to the European Convention. However, there are significant differences, for example, in the powers of the Commission, which are both broad and vogue in the American Convention. The Commission created by the provision of the Convention coincides with pre-existing Inter-American Commission, except that the Commission retains its previous power in respect of states which didn't ratify the new Convention. The American Convention entered into force on 18 July 1978 and the Inter-American Court of Justice of Human Rights was inaugurated on 3rd September 1979. The seat of the court is at San Jose, Costa Rica. The preamble of the convention recognized that the essential rights are not derived from one's being a national of a certain state, but are based upon attributes of the human personality, and that they therefore justify international protection in the form of convention reinforcing or complementing the protection provided by the domestic law of the American states. Litigation before the inter-American systems occur within the legal framework of the main human rights instruments adopted by the Organization of American States. The state parties to the convention have the option to recognize the jurisdiction of Inter-American Court to hear contentious cases against them, and the majority of the state parties have done so. Chapter 1 establishes the general obligation of the state parties to uphold the rights set forth in the Convention to all persons under their jurisdiction and to to adopt their domestic laws to bring them into line with the Convention. The 23 articles of Chapter 2 give a list of individual, civil and political rights due to all persons, including the rights to life in general from the moment of conception, to human treatment, to fair trial, to privacy, to freedom of conscience, freedom of assembly, freedom of movement, etc. The Article 15 prohibits any propaganda for war and any advocacy of national, racial or religious hatred that constitute incitement to lawless violence or to any other similar action against any person on any grounds, including those of race, color, religion, language or national origin, to be considered as offense punishable by law. This provision is established under influence of Article 20 of the International Covenant of Civil and Political Rights. The single article in Chapter 3 deals with economic, social and cultural rights. The somewhat cursory treatment given to this issue here was expanded some 10 years later with the Protocol of San Salvador. Chapter 4 describes those circumstances in which certain rights can be temporarily suspended, such as during states of emergency, and the formalities to be followed for such suspension to be valid. However, it doesn't authorize any suspension of Article 3, right to juridical personality, Article 4, right to life, Article 5, right to human treatment, Article 6, freedom from slavery, Article 9, freedom from ex post facto laws, Article 12, freedom of conscience and religion, Article 17, right to family, Article 18, right to the name, Article 19, right of the child, Article 20, right to nationality, or Article 23, right to participate in responsibility. Chapter 5, with a note to the balance between rights and duties enshrined in the earlier American Declaration of the Rights and Duties of Man, points out that individuals have responsibilities as well as rights. Chapter 6, 7, 8 and 9 contain provisions for creation and operation of two bodies responsible for overseeing compliance with the Convention: the Inter-American Commission, based in Washington, D.C., United States, and the Inter-American Court, headquartered in CEC-UGC, Costa Rica. Chapter 10 deals with mechanisms for ratifying the Convention, amending or placing reservation in it or denouncing it. Various transitory provisions are set forth in Chapter 11. Additional protocols in the ensuing year, the state parties to the American Convention have supplemented its provisions with two additional protocols. The first, the additional protocol to the American Convention on Human Rights in the area of economic, social and cultural rights, more commonly known as the Protocol of San Salvador, was opened for signature on 17 November 1988. It represented an attempt to take the inter-American human rights system to a higher level by enshrining its protection of so-called second-generation rights in the economic, social and cultural spheres. The protocol provision cover such areas as the right to work, right to health, right to food, and the right to education. It came into effect on 16 November 1999 and has been ratified by 14 nations. The second, the Protocol to the American Convention on Human Rights to abolish the death penalty was adopted in Asuncion, Paraguay on 8th of June 1990. While Article 4 of the American Convention had already placed severe restriction on the state's ability to impose the death penalty, only applicable for most serious crimes, no reinstatement once abolished, not to be used for political offenses or common crimes, not to be used against those aged under 18 or over 70 years or against pregnant women. Signing this protocol formalized a state solemn commitment to refrain from using capital punishment in any peacetime circumstances. To date, it has been ratified by 11 nations. The Inter-American Commission is created in 1959 and composed of 7 independent members who meet during sessions held several times annually for 2 weeks each. The Commission also carries out on-site visits to evaluate the general human rights situation in members' countries, publishes country and thematic reports, organizes human rights seminars, conferences, and meetings, and to maintain rapporteurships on various human rights issues. The Commission has multiple roles in relation to the Inter-American Code, like member states of the OAS. It has standing to request advisory opinions and provisional measures. The Commission receives petitions from individuals alleging violation of rights protected in the system of human rights instruments. The Commission devotes some time at each session to public hearing on the admissibility or merit of individual cases under consideration. The Commission, in adopting its own rules for procedures in 1980, included Article 26 stating that provisional measures were called for in urgent cases when it becomes necessary to avoid irreparable damage to person. The system of precautionary measure has been a feature of the Commission's rules of procedures for over 30 years. Article 25 describes the procedure of precautionary measure and how it may be related to subject matter of a petition or case. The adoption of precautionary measures independently of any pending petition or cases. Individual or collective nature of precautionary measures. The procedure seeking withdrawal of the request for precautionary measures and the grounds for the Commission to withdraw its request for precautionary measure and other points. In the amendment process, the Commission gave extensive consideration to the comments and criticisms submitted by many member states, civil society organizations, academics and private citizens from across the world. The court came into being in 1979. It composed of 7 judges and hold sessions annually for 1 to 2 weeks at a time, usually sits in San Jose, Costa Rica. In addition to its jurisdiction over contentious cases, the court exercises authority to prescribe provisional measures. It may also issue advisory opinions at the request of the Commission, OAS member state, and other organ of the OAS. The court issued a landmark judgment on the merit of its first contentious case, Velasquez Rodriguez versus Honduras, concerning forced disappearance. Like the Commission, the court will not exercise jurisdiction over the merits of case until it has satisfied itself that certain admissibility requirements have been met. Therefore, litigation before the court has traditionally consisted of several phases, beginning with consideration of any preliminary objections to admissibility. If admitted, cases have continued to merits phase followed by a reparation stage. The court has the power to convene a public hearing and to receive the testimony of live witnesses. The court publishes a judgment setting forth the violation found and orders the state to carry out reparation measure. The court also monitors its judgment and issues periodic compliance orders. It faces considerable difficulties with respect to compliance with certain elements of its judgment. Once the Commission forwarded the case to the court, it changes roles from neutral arbiter to litigant, representing the petitioner as the sole party opposing the state. The American Convention establishes an optional interstate compliant procedure from Article 45 to Article 51. Assuming the state in question have recognized the Commission competence for this purpose, and if the complaint is deemed admissible, the Commission will seek to reach a friendly settlement under Article 48. If a settlement is not reached, the Commission shall report and may make such proposals and recommendations as it sees fit. Article 50. In March 2007, the Commission presented its first report on such complaints in Nicaragua versus Costa Rica. Among the significant contributions made by the Inter-American Court to human rights jurisprudence in general have been its defense of the rights of indigenous people and its emphasis on the provision of extensive and carefully tailored reparation by states found to have violated their human rights obligation. Douglas Castle has suggested that there are 6 factors which have contributed to the expansive approach taken by the court in relation to reparation. Number 1, it has been pushed to do so by the Commission and by victims. Number 2, substantial compliance by the states with its reparation orders has encouraged a continued emphasis in this regard. Number 3, the increasing acceptance of the code within Latin America. Number 4, its experience with political violence and impunity has encouraged more sweeping remedies. 5, doctrinal evolution on the issue. The influence of the approach of some particularly creative jurists on the code.